All right, welcome back. It's it's been a while, and I'm on a new computer, or at least a different computer. So I was quiet because the volume was different. But yeah, so it's been a bit. You'd think I'd remember how to start a stream, but yeah. So it's been busy. It's been busy, and but I'm back, and frankly, after the Schofield versus Giard, the TikTok psychic, uh, the last filing that I went over last week, I needed a break. I mean, I know not as many of you watch that as you watch the Delete Lawz nonsense, but yeah, if you want to see me absolutely lose my mind, go watch that last video. It it's insane. I can't believe it took me 4 hours to get through that. It drove me insane. But so even though there are a few filings in the Schofield case that I haven't covered yet, I'm not going to do it tonight because I need a break from that. I mean, when Delete Lawz is the less crazy, you know it's bad. So that's what I think we're gonna live in Vegas today because there's nothing new in DeCastro versus Abrams, the Boston case. So there's a lot to get through in Vegas though, and I have a feeling we're not gonna get through all of it, but hey, that just means there will be another stream soon. So few announcements. Like I said, go watch that last video. It's insane. But I am trying something new, and basically I I announced this in that video, but since more of you watch this than Schofield, I'll announce it here too. So I'm trying to do shorts basically, but I need your help. So if there's a particularly interesting less than a minute clip in a live stream, basically, if it's where I lose my mind, if I say something extraordinarily witty, if there's just something less than a minute, give me the starting and ending timestamp just in a comment, and I'll turn it into a short. And I'd really appreciate if you help me that way, because I'm hoping that it'll help to grow the channel. Speaking of which, like, share, subscribe. I know I always forget to say that till the end, but that also helps the channel grow. But yeah, so just give me start and end timestamp less than a minute. If you give me a preferred title for the short, even better. But yeah, so next point of business. So on Monday, July 3rd, I went to a 4th of July barbecue at my mom's church and spoke to a longtime family friend who he's not the head of civil litigation for Salt Lake County, but I think he's basically the deputy head of civil litigation for Salt Lake County. And I was talking to him about sovereign citizens and First Amendment auditors and stuff. And he mentioned that there was a gaggle of First Amendment auditors that came through Salt Lake County a couple months ago, and I was unaware of it because, well, frankly, unless unless something happens to get someone like Dummy Kruger or KFAR or the likes to cover it, I don't watch it because I don't watch frauditors generally. Uh, I mean, I don't even watch them on Dummy Kruger regularly, but I certainly don't watch, say, on Delete Lawz or on uh, Josh Abrams or you you know what I mean. So for those of you who do watch, because like I said, my clearly nothing happened of interest. My friend said basically, yeah, we ignored them. We instructed people to ignore them, which, if you ignore them, they don't get content. So that's why it didn't end up on channels such as Dummy Kruger. But for those of you who do watch, I'm curious if you know who did roll through Salt Lake County recently, because the only thing I remember in Salt Lake County was like a year and a half ago. I mean, it was covered by Schrodinger's cat, so it was a while ago. Moron was auditing in the motor pool parking lot for the Unified Police Department, but that's the only thing I remember specifically in Salt Lake County. There are a few others in Utah, but they were up north, Weber County, Box Elder County. So yeah, let me know if you do know that. But now that I've waffled, let's jump over to the docket for DeCastro versus Las Vegas Metropolitan Police Department. So, like I said, it's been a minute since I've been here, and last I was here, we dealt with the Jason Jensen nonsense and fallout from that. But I think the last that we dealt with from Delete Lawz, what was his well, we discussed the order on the preliminary injunction and that Delete Lawz had requested, which was, of course, denied. And we also did LVMPD's partial motion to dismiss. So what we're going to start with today, I don't think I've covered this one. I'm pretty sure I didn't. We're going to look at Delete Lawz' response to the motion to dismiss. And then we're going to look at LVMPD's response to Delete Lawz' motion for reconsideration for the stay. So basically, Delete Lawz asked for the stay. It was denied. He did a motion to reconsider, which, he didn't bring any new facts, but it was just, no, Judge, you were wrong. So this is LVMPD's response to that motion to reconsider. And then Delete Lawz' reply to that motion to reconsider. We all know he threw a fit about Google being able to do a reply, because you don't get to reply by right in Massachusetts federal court. You've got to ask first, but he threw a fit and then demanded a SIR reply. Well, He's replying to everything in Vegas because you don't have to ask for permission. So we're going to look at that, assuming we get to it. And then Vegas, let's see. Yeah. A reply from Vegas in support of their motion to dismiss. And then today we have the promised by Delete Lawz motion to stay this case, the civil case, from Las Vegas police, and the answer to the amended complaint, because remember, they've only the motion to dismiss did not include 2 of the causes of action, so they've got to answer those, and even though they've got a motion to stay pending as of today. So yeah, with that, let's dive into the documents. So this is Delete Lawz Opposition to the motion to dismiss the amended complaint from all defendants. So let's see why Delete Lawz thinks that it shouldn't be dismissed. I mean, I doubt it's going to be good, but let's see. So, Plaintiff Jose de Castro offers the following opposition in response to all defendants' motion to dismiss the amended complaint by defendants Brandon C. Bork, Brandon Bork, C. Dingle, C. Doolittle, LVMPD, Jesse Sandoval, B. Sorensen, and its joinder of Jason Torrey, titled as Defendants, LVMPD, Officer Bork, Officer Dingle, Officer Sorensen, Officer Sandoval, and Officer Doolittle's motion for partial dismissal. In support of this motion, plaintiff submits a memorandum of law, which is fully incorporated herein. Defendants largely ignore and misconstrue the facts contained in the first amended complaint, and instead seek dismissal based on their own version of events in direct contravention of the standards for ruling on a motion to dismiss. Namely, the court must accept as true the facts alleged in the complaint and must draw inferences in the light most favorable to the plaintiff, citing Baker versus Riverside County Office of Education from the Ninth Circuit in 2009. I remember glancing at this when it came out. I didn't read the whole thing, but I didn't pull it up, but I have a feeling we are going to need the amended complaint. Because when you're dealing with someone who I believe is fundamentally dishonest, like Delete Lawz, you need to call them on their nonsense. And the amended complaint is going to be necessary for that. So, in general, the defendants would have this court believe that plaintiff has pled the facts necessary to give the defendants probable cause that plaintiff committed some unnamed and unpled crime, allegedly related to a traffic code. No. You were arrested for obstruction. That's not in the traffic code. That's in the criminal code. You're saying allegedly related to the traffic code because you were obstructing a traffic stop. Additionally, the defendants would have this court believe that plaintiff has pled qualified immunity for defendants' policies, practices, and behaviors included in this action. This simply isn't the case, as illustrated below. Huh? Why would Delete Lawz plead qualified immunity? That doesn't make any sense. That makes no sense whatsoever. Why would he plead qualified immunity? I mean, the defendants brought up qualified immunity in their motion to dismiss, but that's basically them saying, look, he hasn't pled a valid cause of action because we have qualified immunity on this. So he's trying to argue, I think, that because it, for the purposes of a motion to dismiss, the court has to accept the well-pled, plausible facts from the complaint as true. That's all that goes into the calculation of a motion to dismiss. And because he didn't bring up qualified immunity, the defense can't. But that doesn't work that way. If qualified immunity is available, you bring it up. You say, hey, look, even assuming that everything he says is true, assuming all of the allegations in his complaint are true, there is still not a valid cause of action because the defendants are protected by qualified immunity. But he's too dumb to understand. That's what they're doing. They're not saying that Delete Lawz pled qualified immunity. That's ridiculous. So, did I finish that sentence? Additionally, the defendants would have this court believe that plaintiff has pled qualified immunity for defendants' policies, practices, and behaviors included in this action. This simply isn't the case, as illustrated below. This opposition may seem untimely based on defendants' false certification of their motion, 19, where they allege that all participants in the case are registered CM-ECF users and that service will be accomplished by the CM-ECF system. Plaintiff is not a CM-ECF filer, and plaintiff's status is easily checked. Defendants did not perform their service by mail until approximately 10 days later. Defendants did not even email the motion to plaintiff until June 6, 2023, and defendants refused to amend their certification. So I think what Delete Lawz is doing here is he's trying to have his cake and eat it too. Because we've seen him play the service games. We've seen in Massachusetts, even after he was given access to ECF filing, he has tried to claim to the court, I refuse to accept service by email, even though that's required if you're filing in the case by ECF, because it's automatic. Basically, what you do is you file with ECF, and it automatically emails that filing through ECF to the opposing party. So, but he tries to play the games where he says, if he's late, well, I never got it. If he screws up, that's his fallback. Now, why do I say he's trying to have his cake and eat it too? Well, let's jump back to the docket and right from the start. Docket number 4, advisory letter and consent for electronic service of documents to litigant. So, well, number 1, docket number 1, before the complaint is docket number 2. Docket number 1, motion for pro se litigant to file electronically by plaintiff Jose de Castro. And as a party in the above captioned matter, I, Jose de Castro, respectfully request permission from this court to participate in electronic case filing, e-filing, in this case. I hereby affirm that I have reviewed the requirements for e-filing and agree to abide by them. I understand that once I register for e-filing, I will receive notices and documents only by email in this case and not by regular mail. I have access to the technical requirements to e-file successfully. I understand that permission to e-file may be revoked at any time. So that's docket number 1. He consented to receive service by email. Docket number 4, advisory letter. Basically, it says that he's allowed, but let's see. So he's got to request by motion authorization. Let's see. Oh, sorry. Number 5. So order, it is granted, or it is ordered that plaintiff's motion by pro se litigant to obtain electronic case filing rights pursuant to local rule IC 2-1B is granted. It is further ordered that plaintiff must submit the consent for electronic service of documents on or before May 18th, 2023 to the clerk of court. It is further ordered that the clerk of court must send plaintiff the form consent for electronic service of documents and instructions for the same. Plaintiff is not authorized to file electronically until the consent form is submitted within the time frame specified. Upon timely submitting the consent form, plaintiff must contact the CM-ECF help desk at the telephone number to set up their CM-ECF account, signed by Magistrate Judge Elena J. Ucha. So basically, he asked for and was granted ECF access, but he apparently never finished setting it up. He never contacted the clerk of court or called the help desk. So basically, it's he when he doesn't get served on time or in his preferred manner, but Your Honor, they never mailed it to me. But they don't know that he, they don't know that he hasn't called the help desk. They're going off of the docket, off of the documents, and it says he's been granted access. So when he complains like this, it rings hollow. It's absolute nonsense. But he plays games, and it's got to stop. At some point he needs to face consequences for it. But continuing, for the reasons set forth below, the court should deny the defendant's motion to dismiss. Facts: Plaintiff was illegally arrested by defendants while exercising his civil rights in violation of his civil rights pursuant to 42 U.S.C. Section 1983 and similar rights under Nevada law, and in retaliation of plaintiff's exercise of his civil rights. Without reasonable suspicion, while plaintiff was exercising his civil rights, defendants, LVMPD, and its employees used excessive force to detain plaintiff and deprive plaintiff of his property, including his cell phone. Without good cause, plaintiff was handcuffed while being detained for approximately 35 minutes. You were under arrest at that time. When you're under arrest, you are handcuffed. I mean, the good cause for being handcuffed is being under arrest. While being detained, plaintiff's ulnar nerve was pinched by defendants for approximately 20 minutes, causing pain and leaving plaintiff injured and still under medical care as of the drafting of this pleading. And yet, we have nothing but his conclusory statements. Because here's the thing. In order, well, he should have some form of medical documentation in order to survive a 12b6. He doesn't. So basically, this is nothing but a conclusory statement. Without probable cause, plaintiff was arrested for alleged misdemeanor violations, which are not even arrestable offenses according to LVMPD policies. Plaintiff was searched pursuant to an illegal arrest, making the search a violation of plaintiff's rights. Which policy? That once again, a conclusory statement. Conclusory statements alone are not enough to survive a 12b6 motion. For those of you who did watch my last video from Schofield versus Guillard, you'll already know this. But for those of you who didn't, I spent a half hour maybe going over Twombly and Iqbal, which I've discussed in relation to the Delete Lawz cases before, but I went more in depth into especially Iqbal, which basically says conclusory statements alone are not enough. You need sufficient facts to be pled. And they have to be plausible facts in order to survive a 12b6 motion. I'm also using a new mouse, and it's way too easy for me to right-click this one, as you have probably seen multiple times already this stream. But he's stating as conclusory that it's not arrestable according to LVMPD policies. Which policy? You've got to tell us which LVMPD policy is it not arrestable. I mean, misdemeanors are arrestable. Period. You'd be hard pressed to tell a federal court, well, they can't arrest me for misdemeanors. You can be arrested for civil infractions. You probably shouldn't most of the time, but you know, if you refuse to sign the ticket, that's your promise to appear. Hey, or you know, During the foregoing incidents, defendants made statements showing that plaintiff's detainment and arrest were based partially on the color of plaintiff's skin and plaintiff's political viewpoint. A supervisor of the LVMPD is a defendant that participated in the injuries in this action. That supervisor stated that the illegal actions of the defendants was an established policy of the defendant organizations. Huh? For starters, they're not illegal actions, but which supposed illegal actions are an established policy of the LVMPD? Arresting you for interference? Is that the established policy? Arresting people who interfere? And we've seen the video. It was not partially based on the color of his skin. The comment about the color of his skin was specifically his lips, because they led the police to suspect that he was on drugs. That's very different than racial animus. Defendants in their motion make many allegations about the reason of the plaintiff's arrest that contradict defendants' wouldn't that be plaintiff's First Amendment complaint? Without defendants including any declarations or documentary evidence in support of their allegations. You haven't submitted any declarations. I mean, just signing at the bottom does not a declaration make. Your First Amendment complaint is not a declaration. That's ridiculous. You say, well, they haven't submitted any declarations, but you haven't either. I mean, let's look. Complaint, receipt, civil cover sheet. No declaration. Well, let's scroll down and amended complaint. No declaration. Wow. Imagine that. Let's see. Motion to dismiss. No declaration either. But that's fine. They don't really need one. But defendants have continued to participate in the malicious prosecution of plaintiff, and plaintiff expects to request for leave to file supplemental claims related to malicious prosecution soon. Seriously? Supplemental complaints. Now, he loves his supplemental complaints. Now, as we know from the Boston case, supplemental complaints are where the defendants have done something since the start of the case. Well, for starters, he was charged with his crimes before the start of the case. And so unless the supplemental complaint is for not dropping the criminal case, what it's ridiculous. Or is it that, you know, what interactions they've had with him on subsequent traffic stops, or, well, subsequent audits, I should say. It's just it's all complete nonsense. Memorandum and points of authorities. 1. Indeed, the subject incident was not a traffic stop. Yeah, it was. Well, I mean, we assume it was a traffic stop because we don't know what the lady was stopped for. Because the subject incident is the police interaction he interfered in. We assume since the woman in that interaction was in her car, we assume it was a traffic stop. But we don't know. But neither does Delete Lawz because he rolled up on it after it was in. So he doesn't know. He's just guessing. But for him to say, well, indeed, it wasn't a traffic stop. He wasn't there. He wasn't there. But in the motion 220 through 23, defendants claim that the subject incident was a traffic stop, citing the First Amendment complaint. This is false, and it is not alleged in the First Amendment complaint. Well, let's take a look at the First Amendment complaint. Okay, so it was a police officer interaction. It was a police interaction. Do you know what a traffic stop is? It's a police interaction. So, plaintiff happened upon a police interaction between a woman sitting in a silver Hyundai Elantra and Bork, who was sitting in a Ford Police Interceptor with the LVMPD logo on it. And he'll refer to her as Jane. So here's the thing. This is a distinction without a difference. He's saying, well, this wasn't a traffic stop, therefore, I didn't interfere with a traffic stop. I interfered with a police interaction. That doesn't help him. Or in this case, the incident occurred in a giant parking lot in front of a Rollin' Smoke barbecue. Additionally, defendants attached no declaration or documentary evidence to support their allegation. Just because they don't call it the same thing as you doesn't mean it's contradictory. You call it a police interaction, they call it a traffic stop. That's not contradictory. That, like, even if, so you take the motion to dismiss and you substitute traffic stop out and replace it with police interaction. Does that make the motion to dismiss less valid, less likely to succeed? No. So why is he spending time arguing it? Because he's a moron. in the motion 310 through 11, why is he doing this like a time signature? 3 minutes and 10 seconds through 3 minutes 11 seconds. I'm assuming he means page 3, paragraph 11, or line 10, line 11, paragraph 10, paragraph 11. I assume that's what he means, but this is in the Schofield motion, I complained about the way she was citing to the motion to dismiss. This is equally bad, equally wrong, but in the opposite, in that this is too short and terribly formatted, whereas hers was too long and overly broad. But in the motion, defendants claim that Bork told the traffic detainee she was free to go, and cites the First Amended complaint. The First Amended complaint does not allege that Jane was detained. Moreover, defendants attach no declaration or documentary evidence to support their allegation. Defendants have attached no evidence of an agreement with the private property owner allowing the LVMPD to enforce traffic laws on the property. Delete Lawz provides no evidence of an agreement with the private property owner allowing him to conduct First Amendment audits on their private property. It works both ways, moron. Except if someone is pulled over and the police initiate a traffic stop, and instead of pulling over onto the shoulder of a busy road or in a travel lane, they pull into a parking lot. The police don't suddenly lose authorization to conduct that traffic stop. It's not home base. That's ridiculous. But so this arguing for the private property rights of the parking lot owner at best is a red herring. At best. Because it's completely irrelevant. But they offer no declaration or documentary evidence that Jane was detained. Oops, I was closer to it before. So okay, right here. In the amended complaint, plaintiff continued to assert his rights and notified Bork that plaintiff was a member of the press, at which time Bork got upset and said he was detaining plaintiff. Sorry. So Bork told Jane to leave. So he had her in a police interaction that she was not free to leave until Bork told her she was free to leave. But there's no evidence she was detained. Even if she wasn't detained, even if she was free to leave, even let's say Let's pretend. Let's say that Jane had flagged down the officer to report a crime. She was in her car still, and Officer Bork went back to his car to radio in the report of the crime to dispatch. That's still a police interaction, okay? But she's not detained. She is free to go. Delete Lawz trudging in there and interfering. He's still interfering in police business. He's obstructing police business, making it more difficult for the police to conduct their business. That's arrestable. But once again, it does not matter. He's arguing nonsense. Brandon Bork did not use the word obstructing, but in a threat to retaliate for plaintiff allegedly not respecting a citizen's privacy rights, and cites no actual law violation. Here's a fun story. Well, not a story, but fun fact. Police do not have to tell you why they are arresting you. They do not have, there are no magic words. Sovereign citizens believe there are magic words, but there are no magic words. You can be arrested for obstructing even if obstruction has never been said until it's on the criminal complaint. If you were obstructing, you can be arrested for it. In fact, let's see. Plaintiff started recording the police interaction on his phone and moved to a position approximately 10 feet away from Jane and started talking to her. Bork got out and told him to back up, which plaintiff immediately did, giving Bork an additional 5 feet. Bork told plaintiff to back up again or he would detain plaintiff, at which time plaintiff began asserting his right to record the interaction, saying, "I'm more than 10 feet away. I'm a member of the press. I have a right to be here." Bork threatened to detain plaintiff for obstructing. Bork threatened to detain him for obstructing. That's in the amended complaint. Bork didn't use the word obstructing. Delete Lawz is such a moron that for starters, Officer Bork didn't have to use the word obstructing, but Delete Lawz said in the complaint that he used the word obstructing, that he told him not to obstruct, stop obstructing. He is the stupidest person on the planet. I've decided. It's official. He is the stupidest on the planet. Schofield, or sorry, not Schofield. Schofield is the professor. She's smart. Guillard is the most delusional on the planet. DeCastro, stupidest. Guillard, most delusional. I have decreed it. So, well, this is good English. And, comma, this is a new sentence, by the way. And, comma, cites no actual law violation. That's a good sentence fragment. Besides which, it's irrelevant. As I said, you don't have to be told what the law violation is. I mean, in the First Amendment complaint, you did, because let's look at it again. Let's look at it again. Let's look at it again. Bork threatened to detain plaintiff for obstructing. Right there. But then, magically, in the opposition to the motion to dismiss, well, Bork didn't use the word obstructing, even though, let's look at it again. Right there, obstructing in, let's scroll up just to be sure. This is the first amended complaint. Wow. How do you get this stupid? How do you get this fundamentally dishonest? I'm eager to see the brilliant Craig Anderson's reply. In the motion, defendants claim Bork warned DeCastro he would detain DeCastro for obstructing if he did not move further away from the detainee, citing the First Amendment complaint. This is false, and it is not alleged in the First Amendment complaint. Bork threatened to detain plaintiff for obstructing if plaintiff did not respect a citizen's right to privacy. No. He said she had. He did say she should have a right to privacy, but he didn't say that's what the obstructing was. That both of those can be true. Bork was simply threatening to detain plaintiff under false pretenses of obstructing for plaintiff's failure to comply to Bork's wishes that were unrelated to obstructing. Bork's wishes were, which are not backed by statute. That's because there isn't a statute saying you have a right to stand within this distance. You have a right to interact with a detained subject. Obstruction is a very, it's a fact-specific crime. And I mean, Bork's wishes are not backed by statute, but obstruction is a statute. He decides if you are obstructing. Now, the court may decide that he was unreasonable. Like, if he's 50 feet away, it would probably be unreasonable to say he was obstructing. But 10 to 15 feet away and being noisy, being a jackass, yeah, it's reasonable to say he's obstructing. If plaintiff had illegally obstructed anything, which plaintiff denies, plaintiff certainly had no warning of that. Except for Officer Burke saying, back up, stop obstructing. That's the warning. He doesn't have to say, this is your official warning to stop obstructing. Going once, going twice, now you're obstructing, now you're detained. No, if he says, back up, and you don't, you're obstructing. In this case, it was back up. No, back up. Don't obstruct. No. Okay, man, you're free to go. You're under, now you're detained. If plaintiff had violated a law in Bork's presence, there would have been no reason to threaten plaintiff's immediate freedom with detainment while Bork investigated. Rather, an immediate citation or arrest would have been appropriate. Additionally, defendants do not include any evidence that support their allegations that plaintiff was warned against simple obstructing. Defendants also cite no statute that plaintiff was violating as obstructing. So here's the thing. Here's the thing. They don't have to arrest you immediately. Like, if he had cooperated, they could have still charged him. But, part of the investigation while he is detained is IDing him. They didn't, like I said, they didn't have to arrest him. They could have, if he cooperated, ID'd him and cut him loose. They didn't, because they realized if they did, he'd just follow Officer Bork to the next stop and obstruct there too. But them not immediately arresting him, them conducting a reasonable investigation first, or at least attempting to, it went from investigation, detention and investigation to arrest very quickly, because he tried batting Officer Bork's hand away. They cite no statute. Obstructing, that's the statute. Plaintiff did not refuse to comply. In the motion, defendants state Bork attempted to detain DeCastro. DeCastro refused to comply, citing the First Amendment complaint. This is false and is not alleged in the First Amendment complaint. What is alleged in the First Amendment complaint is that Bork was visibly upset and very interested in manhandling plaintiff. Plaintiff's only requirement while being detained is to not flee, and possibly to allow himself to be frisked and handcuffed if Bork had reason to believe that plaintiff was armed or would flee. Not only did plaintiff not have to comply with being manhandled, but plaintiff did substantially allow the illegal manhandling anyway, while protesting the illegal detainment as alleged in the First Amendment complaint. Defendants offer no evidence to support their contradictory statements. Let's see. Bork told her to leave and started walking aggressively toward plaintiff as if to use force, and plaintiff took a step back to prevent any physical confrontation. Plaintiff continued to protest Bork putting his hands on him unnecessarily, but Bork was patently interested in manhandling plaintiff in some way and said, "Listen, I am going to put my hands on you." Bork did indeed batter plaintiff. Well, he didn't, but he did put his hands on him. While plaintiff was firm in his verbal tone, he never screamed or yelled. He never threatened defendants and never said or did anything that would have led a reasonable law enforcement officer to fear for their safety or to suspect that plaintiff committed or is planning to commit any crime. But let's see. Let's read between the lines. I mean, we've seen the video, so we know that Delete Lawz did try to swipe away Officer Bork's hand. That is resisting. But even here, plaintiff took a step back when an officer is walking to you to handcuff you, if you step back, that's resisting. It's resisting without violence, but I mean, it can be resisting. Of course, he leaves out that he tried to prevent Officer Bork from handcuffing him. That was resisting. That was definitely resisting. That wasn't even passively resisting. Defendants admit that illegal detainment, false arrest, and excessive force are within their policy, endorsed by their supervisor in the motion at 318 through 3. What is. They have not admitted that illegal detention, and it's illegal detention, not illegal detainment. Learn to conjugate, bro. But let's see. I assume that's page 18 of the motion to dismiss. So let's take a look at that. Let's see, what was it? 318 through 25. So DeCastro alleges one of the defendant officers repeatedly squeezed plaintiff's elbow, placing pressure on DeCastro's ulnar nerve and causing DeCastro severe pain. DeCastro then threatened to sue the officers at the scene. DeCastro further alleges that he was patted down several times, and during the final pat down, an officer struck DeCastro in the groin with a closed fist. Eventually, defendant Erland Jason Torrey arrived on the scene. Sergeant Torrey authorized the officer's behavior as being within LVMPD policy and said that DeCastro should be arrested. You'll notice. You'll notice. That is one paragraph. So DeCastro's allegations. Let's look at that again. DeCastro alleges that one of the defendant officers repeatedly squeezed his elbow, placing pressure on his ulnar nerve, causing severe pain. DeCastro then threatened to sue the officer at the scene, and he further alleges he was patted down several times, and during the final pat down, an officer struck DeCastro in the groin with a closed fist. So those are his allegations. They do not say Sergeant Torrey authorized those allegations as being within department policy. He's saying the officer's actual actions were within their policy. Besides which, he didn't have, on the scene, DeCastro didn't say, "Oh, my ulnar nerve, you've caused permanent damage to my ulnar nerve." So Sergeant Torrey couldn't have endorsed that as within departmental policy on the scene. But once again, that's a separate paragraph. That's a new thought. It's moving on. Defendants admit to changing their story in the police report. In the motion, defendants admit to changing their story and arresting plaintiff for things that are not true and or are not crimes. Let's see. As noted in Officer Bork's report and affirmed by Sergeant Torrey, the reasons why DeCastro was arrested was for engaging with a detained driver, refusing to give an officer reasonable workspace, and refusing to obey lawful commands after being advised he was being detained. Do you know what those are? Those are obstructing the officer. Like they're obstructing, as I said, is a fact-specific crime. These are the facts alleged. But basically, these are, DeCastro obstructed by engaging with a detained driver. DeCastro obstructed by refusing to give an officer reasonable space to work. DeCastro obstructed by refusing to obey lawful commands after being advised he was being detained. That's not them changing their story. He was arrested for obstructing. That was how he was obstructing. But here's the thing. They didn't change their story, like he says. And those are crimes. They're the crime of obstructing. But let's say they did change their story. Let's say that on the scene, Officer Bork said, "I am arresting you for obstruction for engaging with a detained driver." And then Sergeant Torrey told him, "You are being arrested for the other stuff, for refusing to give Officer Bork adequate space to conduct his traffic stop." That doesn't make the arrest illegitimate. If he did both of those and Officer Bork in the first instance said, "You're being arrested for this," and then Sergeant Torrey told him the other, here I know this is difficult for Delete Lawz to understand, being that he is, as I have decreed, the stupidest person on the planet. They don't have to make up their mind immediately what you're arrested for. As long as they're arresting you for something legitimate, that's all that matters. That's all that matters. It's like, let's say I am pulled over. I'm driving 100 miles an hour in a 45 zone. So in most jurisdictions, that's felony speeding. Okay. I get out of the car and the officers realize that I am drunk as a skunk. So they put me in handcuffs and say, "Joe, you're under arrest for driving under the influence." And only for driving under the influence. That's all they tell me. They do not say, "You're under the arrest for felony speeding." When I get to my arraignment and the judge reads, "Joe, you are accused of driving under the influence and felony speeding." It's whoa, judge. The officers didn't tell me it was felony speeding. They didn't tell me I was under arrest for felony speeding. That's what the arraignment's for. They didn't even have to tell me I was under the arrest for DUI. They could have just said, "Joe, you are under arrest." I could protest all I want, but as long as it was a valid arrest, them not telling me what it was for doesn't negate the arrest. And in fact, let's say, back to the first set of facts, they arrest me and say, you're under arrest for driving under the influence. They don't tell me felony speed. I show up at my arraignment and the prosecutor thinks that the officers did a bad job documenting the probable cause for why they thought I was driving under the influence. Let's say they just were going off their observations that I couldn't walk, but you know, I mean, I have one leg, so you know, that they hold that against me. I'll get up in court and walk, and you know, so that might not be the probable cause they thought it was, but so they don't even bother with the breathalyzer back at the station because they think they have enough just based on me being wobbly getting out of the car. But that's all they told me I was under arrest for. So I get to my arraignment and the judge says, all right, Joe, you are accused of felony speeding. Hang on. They changed their mind. That you know, they changed their story for why they arrested me, and they're arresting me for you know, they arrested me for driving under the influence, but now you say it's for felony speed? That's a completely different reason than why they arrested me, so you've got to let me off the hook. If they had probable cause for felony speed, it's still a valid arrest. Defendants admit to lying in their report and arresting plaintiff for filming the police. In the motion, let's see, 328 through 4, 1 through 4. Officer Bork's report further stated DeCastro had admitted to getting in trouble numerous times in the past for the same reasons, and his habitual behavior of obstructing police officers and claiming it was justified because of his right to film the police would continue in the area if he was not cited. He is so fundamentally dishonest. I mean, even within the lines he cited. So that they don't admit to lying about what he said. And you'll notice. So let's read this and then go back. So defendants admit to lying in their report and arresting plaintiff for filming police. In the motion, defendants admit to lying about what police said prior to arrest, and defendants admit to arresting plaintiff because of his right to film the police would continue in the area if he was not cited. Although defendant's police report did say that plaintiff admitted to being in trouble numerous times in the past, the plaintiff only alleges that's what the police report said, that not that it was true. Further, at First Amended Complaint, paragraph 46, plaintiff denies having said that he was in trouble numerous times, and plaintiff alleges the opposite, Defendants offer no evidence to support their contradictory statements. So they have not admitted that they arrested him for filming. It says Bork's report stated that he admitted to getting in trouble numerous times in the past for the same reasons, and his habitual behavior of obstructing police officers and claiming it was justified. So let's see. So they admit to arresting plaintiff because of his right to film the police would continue. Let's see. Okay. So let's look at this again. So they admit to arresting plaintiff because of his right to film the police would I mean, the way he threw that quote in there makes for a terrible sentence, if I'm going to be the grammar police. But it's just patently false, because they say they arrested him because of his habitual behavior of obstructing police officers and claiming it was justified because of his right to film the police, and that it would continue in the area if he was not cited. So he's claiming that his justification is why he was arrested. Or he's claiming they admit that they arrested him because of his justification. But no, they arrested him because he obstructed and admitted it was a habitual behavior. But let's look at this. What was it? Paragraph 46. Plaintiff did not admit to being in trouble numerous times, but said the opposite. The facts in the incident report were either fabricated or merely pretextual. Even if the facts set forth in Defendant Bork's report were true, which the video evidence disputes, those facts still did not give rise to a reasonable suspicion to detain plaintiff. Oh yeah, this is where he cited Terry versus Ohio. And whether he said, he's playing with semantics here. He didn't admit to being in trouble numerous times, but said the opposite. But he says, I do this all the time. I do this all the time. Look me up. I'm Delete Lawz. I do this all the time. However he said it led the officers to determine that he did it all the time, that it was habitual, and that if they didn't arrest him, he'd continue doing it, and Officer Bork wouldn't get anything else done the rest of the day because of his continued obstruction. That's what their argument is. But he's stupid, so he misconstrues their argument. Defendants intentionally or incompetently misstate the majority of plaintiffs' claims. That's because they're going by the actual body cam video. They're stating the actual truth. They are adding what you left out. That they are doing it without your twisting. But here's the thing. Here's the thing. Other than your conclusory statements, other than highlight that so I come back to my place. Other than, defendants admit that illegal detainment, false arrest, and excessive force are within their policy endorsed by their supervisor. Other than conclusory statements like that. Other than, but plaintiff did substantially allow the illegal manhandling anyway. I mean, he didn't allow it. He took it. But it wasn't illegal manhandling. But that's just a conclusory statement by him anyway. It's a misstatement of the law, which, funny enough, for the purposes of a motion to dismiss, the judge has to take well-pled factual allegations as facts. They don't have to take misstatements of the law as fact. So when he says something's illegal, that really isn't. They don't have to take that as fact because that's a misstatement of the law. And the judge decides the law. The jury doesn't decide the law. I don't decide the law. The lawyers don't decide the law. The prosecutor doesn't decide the law. The defendant doesn't decide the law. Delete Lawz doesn't decide the law. The judge decides the law. The judge. So let's slow it down. Slow it down for a minute. Even though, the number one complaint, number one criticism in the comments is why you talk slow. But let's slow it down for a minute. In a trial by jury, the jury decides the facts. The judge decides the law. So the judge, basically, the judge makes the decisions concerning the law, which is why, let's say, an evidentiary concern. Well, the rules of evidence are law. Okay? They are law. Or the rules of civil procedure are law. So the judge decides what hearsay is. That the judge decides this is hearsay because that's a matter of law. They've got to analyze the facts as to if it is hearsay, because it's still a factual matter. Who said what and where and to whom, but the judge has to determine it as a matter of law. Or the rules of civil procedure. So evident or discovery disputes. The jury doesn't decide that because it's a matter of law. But the jury doesn't decide, what obstruction is. They don't determine. I'm not going to quote the exact statute for obstruction because, frankly, I don't know Nevada's exact statute for obstruction off the top of my head. But let's go with murder, first-degree murder. Frankly, I don't know that off the top of my head either because it's different from jurisdiction to jurisdiction, but it's generally going to be something like, the intentional killing of a human being with malice, with the general common law would be malice aforethought. So the judge decides, the judge tells the jury, this is what the intentional killing of a human being is. This is what malice aforethought means. Now go and apply the facts to the law that I just told you. You know, for those of you, you know, I live streamed the Darrell Brooks trial. Very few people watched me because I'm tiny, and that was kind of the relaunch of my channel. And most of you watched it with Law Talk with Mike or Emily Baker, or you know, I think Rakeda did it, and you know, it was a big deal. But you know, we sat through the opening jury instructions for that. We sat through the ending jury instructions where the judge read out, you know, this is what this charge is. This is what you must find from the facts in order to convict. And it took hours. And I'm on such a far tangent that I forgot what got us here. Well, it was about him and his conclusory statements. Did I miss? I screwed up and unhighlighted the point I was at. That was dumb of me. Okay, I think I was here. But yeah, defendants intentionally or incompetently misstate the majority of plaintiffs' claims. In the motion, defendants largely assume state law claims where there are also federal claims and skip over all state constitution claims in plaintiff's first amended complaint. Let's see. I fail to see where he alleges Nevada constitutional violations in his complaint, but the reason so here's the thing. I don't know what he means by they largely assume state law claims where there are also federal claims and skip over all state constitution claims. The federal claims, well, the state law claims basically are you know, negligence and invasion of privacy, false arrest and imprisonment, battery, assault. And so some of these are not even mentioned in the motion to dismiss because they're not included in the motion to dismiss. So they're in the answer, which was filed today. So why would they spend any real estate on that if they're not moving to dismiss them on a 12b6 motion? But you know, the 1983 is the federal statute. So that would be the federal claim. And that's the mechanism to enforce the constitutional violations. But frequently, the state law claims would be the mechanism where you say, well, the police assaulted me, which was unlawful, and that is a violation of my constitutional rights. You know, 14th Amendment constitutional rights. And so I'm suing under Section 1983. But I don't get what he's trying to say here. It's nonsense. And intentionally or incompetently misstate the majority of his claims. That could be because his complaint is gibberish. So they're doing their best to interpret gibberish to restate his conclusory statements, ignore his conclusory statements, point out his conclusory statements, state them as the actual facts. I don't know what that is supposed to mean. So, defendant officers have admitted to acting under color of law. Motion 519 through 20. Here's the thing. They were acting under color of law. But, like, sovereign citizens think that acting under color of law in and of itself violates your rights. It doesn't. It doesn't. It's only if you do something that violates your rights while acting under color of law that, you know, it's A and B. It's not just A. So, yeah, they don't dispute that they acted under color of law right there. Therefore, the task of this court is to determine whether the defendant officers violated the Constitution. That's what I just said. But additionally, they've raised the affirmative defense of qualified immunity. But Delete Lawz seems to think that because he didn't raise qualified immunity in his complaint, that the officers can't do it. But it's nonsense. So, qualified immunity is more appropriate for summary judgment than dismissal. Defendants cite Hunter v. Bryant to show that deciding qualified immunity should be done at the earliest possible stage in litigation. Yet, Hunter was determined at summary judgment. Yeah, but it said that it should be at the earliest stage of litigation. You, why? Why? You say it's more appropriate at summary judgment, and Hunter was decided at summary judgment. Well, tell us why. Tell us why it shouldn't be decided at a motion to dismiss stage. Because you know, I haven't read Hunter versus Bryant, but I'm sure it says something like, if qualified immunity applies, it should be decided at the earliest stage possible so that we can avoid the time and expense and the undue burden on the courts and the parties of continuing a case that would be dismissed anyway because the defendants have qualified immunity. So if they can decide on a motion to dismiss stage that they have qualified immunity, well, that would be the earliest opportunity. That would be the earliest stage possible in the litigation. It doesn't, if Hunter versus Bryant says it should be decided at the earliest possible stage in litigation, as long as that earliest stage is summary judgment or after. But if it said that, he would have quoted it. But bring a competing citation. Bring something that says qualified immunity analysis is improper on a motion to dismiss. Your entire argument, though, is, well, the case they cited was at summary judgment stage. Well, let's see. Why was it at summary judgment stage? Maybe it's because in Hunter versus Bryant, they pled sufficient facts that, if taken as true, would support. So here's the thing. Here's the thing. They very well could, for I think it's the assault and battery charges that they're not moving to dismiss in their 12b6. They very well could be asserting qualified immunity in their answer. In fact, I haven't even looked at this. So they, as for assault, they deny. That's all you have to do in an answer. Battery, they deny. Affirmative defenses. Qualified immunity. So they're raising qualified immunity as a defense in the answer. And it doesn't say we have qualified immunity for everything, just for these. It's blanket. They're saying we have qualified immunity, period. So with the answer, they could swiftly do a motion for summary judgment. I mean, in fact, they could have, instead of a 12b6 motion, they could have just gone straight in summary judgment motion. Now, that might not have been the smartest move, but they could have. Now, what's the difference between summary judgment and a motion to dismiss? So, motion to dismiss is based off of the complaint, and it's, is there sufficient, are there enough well-pled facts that are not conclusory statements? So conclusory statements don't work. Implausible facts don't work. So if you pled aliens in your complaint, even though that's a fact you alleged, the court can say that's implausible. That doesn't count because, see my last video. Iqbal and Twombly require plausible, well-pled, plausible facts that are not mere conclusions, so not conclusory statements. So if there are enough such facts that on its face, without the defenses, your complaint, the cause of action could have occurred. So that's why they're not disputing or not moving to dismiss the assault on a 12b6, because even though there's not much there and they are disputing it, he did say they hit me in the nuts, and that's that's an unwelcome touching that blah blah blah. So that's enough probably to survive a 12b6, although I'd say qualified immunity still should be a analysis in that 12b6, but they didn't do it, so I understand. But so in a summary judgment, though, it's what you do is you make a judgment off of the uncontested facts. So you look at the plaintiff's factual allegations, you look at the defendant's factual allegations, and you go off of that. So but if there are disputed facts, then you can't. So it's hard to explain. But either way, the point is they very well could well, okay, I can state that better. So in the 12b6, they go off of the facts pled in the complaint. For the 12b6, the facts are the declarations, the exhibits. So when the officers and Delete Lawz, submit the body cam as an exhibit. That's what the court, in addition to the pleadings, and that's what the court will decide a summary judgment on. And so that would be the earliest stage possible to decide the assault claim and the battery claim. For the rest of them, the earliest stage possible to decide would be this 12b6 motion. So, defendant's false arrest legal argument fails. The motion cites the original complaint at ECF number 1 instead of the active first amended complaint at number 13, and makes arguments about the now irrelevant document. Hang on. 614 through 714. So 42 USC 1983. But the amended complaint is 42 USC 1983, first cause of action. Hang on. It's citing to ECF number 13. Well, what on earth is it? I mean, he is fundamentally dishonest. At 614 through 714, cites the original complaint at ECF number 1 instead of the active first amended complaint at ECF number 13, and makes arguments about that now irrelevant document. Except citation, ECF number 13 at paragraphs 21, 22. ECF number 13 at 22. ECF number 13 at 22. ECF number 13 at 23. ECF 13 at 23. So what he's is he stupid or is he lying? I mean, I know he is stupid and he is a liar, but I don't know which is the cause here. Because I mean, I don't see any place where they even mention the original complaint in there. But like, even if they just like, especially not ECF 1, besides which it's ECF 2, because ECF 1 is his motion to be granted ECF access. But like, even if they call it the complaint instead of first amended complaint, the citations are all to ECF number 13. So this whole number 10 is either a lie, a complete misstatement of the motion to dismiss, or he is stupid, or both. But plaintiff properly alleges false arrest. Plaintiff was arrested. Defendants did not have probable cause. First amended complaint at 46. Well, yes, he was arrested. 46. Wait. Where am I? I'm getting lost because this is such nonsense. So paragraph 46. So well, he says 46 means it's his citation for no probable cause for the arrest. Let's see. Plaintiff did not admit to being in trouble numerous times, but said the opposite. The facts in the incident report were either fabricated or merely pretextual. Even if the facts set forth in defendant Bork's report were true, which the video evidence disputes, those facts still did not give rise to a reasonable suspicion to detain plaintiff, citing Terry versus Ohio, and certainly did not furnish probable cause to arrest plaintiff. Plaintiff stated early in the encounter that he had no criminal record and there wasn't any criminal behavior. At that point, a reasonable officer would have left the plaintiff alone. Bork never told plaintiff that there was an investigation or that he was interfering with it. Rather, Bork only demanded that plaintiff respect Jane's privacy in public. Defendant Bork seemed only intent on preventing plaintiff from recording the police interaction. This is probably because plaintiff has recently covered several stories about LVMPD that went viral on the internet. So that he cites this as there was no probable cause. Well, it certainly did not furnish probable cause to arrest plaintiff. That's a conclusory statement. That's conclusory. Captain Conclusory is citing to a conclusory statement to support his assertion that they didn't have probable cause. This is conclusory inception, concluception. It just doesn't make sense. It doesn't make any sense because that's not the standard. Him saying it's not probable cause that's not a fact. That's not a factual assertion. That's a statement of law. The judge decides the statements of law. It's a conclusory statement at law at that, and a wrong conclusory statement at law. Bork did not have probable cause to arrest plaintiff for obstruction. Motion 715 through 9-3. Defendants fail to ever cite a statute that plaintiff violated, but only allude to some traffic code related to obstruction. Probable cause requires a code and evidence of its violation, neither of which have been alleged. Defendants fail to allege how plaintiff obstructed, what statute prohibits obstructing, how the police officer was obstructed due to plaintiff's behavior and could have taken alternate actions that didn't violate 42 U.S. Code sections 1981, 1983, or NRS 171.1233. They only allude. Wait, what was it? 7:15 to 9:3. That's an awful lot. Well, I'm looking at his complaint, and so I'm looking at the wrong section, but let's look at it again. 7:15 to 9:3. So he had probable cause to arrest DeCastro for obstruction. So under NRS 197.190, it's obstruction to impede and prolong an investigation. Hey, that's a citation to lawful law. That's not vague. That's I don't get it. I do not get it. Probable cause requires a code and evidence of its violation, neither of which have been alleged. But they only allude to some traffic code related to obstruction. That is the law. That is the code. I mean, some traffic code. Probable cause requires a code and evidence. I realize sovereign citizens don't think that the code is law, that statutes are law, but he's asking, well, what law was I arrested under? You haven't alleged it. You've only alleged some random traffic code for obstruction. All they did was specifically allege what I was arrested under, but that's not good enough for me. That's too vague for me, even though it's the exact code section. Yeah, we're not going to get through all of these documents today. I think after this, I'm going to skip to the reply in support of the motion to dismiss. So basically, the reply to this document, and then we'll get the rest of it next video, hopefully. But we'll see how long the rest of this takes. And he's like, him alleging that they violated NRS 171.1233. Well, that's specific enough. But when they alleged that he violated 197.190, that doesn't count. 197.190 doesn't count, but 171.1233 does. I don't get it. I don't. It's just like the ECF filing. He wants to have his cake and eat it too. Statutes apply if they help him. If they don't help him, he'll pretend they didn't even cite it, and even if they did cite it, it's vague. Further, defendants cite Spencer v. Rao from the Western District of Texas, 2007, a Texas case that couldn't have been about enforcing a Nevada statute. But let's look. Let's find it. So, C. Spencer versus Rao, where probable cause existed to arrest a bystander attempting to help at a traffic accident after bystander ignored multiple requests to return his car. So, he's right. He's right. This isn't about Nevada law. But in federal court, it's still persuasive that it's enough. So let's put it this way. Texas has an obstruction law. This said, under the Texas obstruction law, there was sufficient probable cause to arrest a bystander attempting to help at a traffic accident after the bystander ignored multiple requests to return to his car. So that they're basically just saying, hey, look, federal courts, because this is Western District of Texas, it's federal. So I'm guessing that the Spencer, I'm assuming is the bystander in this, sued saying, hey, this was a violation of my civil rights. You can't arrest me for obstruction because I offered to help. But Texas, the Western District of Texas disagreed and said there was probable cause. That's all they're saying here. That's all that the LVMPD is saying. They're not saying that, hey, the Western District of Texas found that there was probable cause under the Nevada obstruction statute. That's silly. That's silly. But so yeah, they weren't enforcing a Nevada statute, but they still said, hey, there's probable cause if you're obstructing, but who cares? Who cares? So Zhao versus Desert Place Inc. from the Ninth Circuit, where Zhao gave false information while being legally detained and was not participating in the exercise of her constitutional rights. Okay. But you don't have a constitutional right to obstruct. How many times do these morons need to hear? You do not have the constitutional right to obstruct. Yes, you have the constitutional right to film in most places. You filming, just because freedom of the press doesn't mean if you are doing something else that's illegal, it's not a shield to protect you from being arrested for something that is actually illegal, something that is actually obstructing. Kelly versus Las Vegas Metro Police Department from the District of Nevada in 2014, an unpublished district court case with a pro se complainant where an officer gave orders related to public safety to an armed suspect, where that suspect was not participating in the exercise of his constitutional rights. Once again, you're pro se. You're frequently armed, even. As far as I know, it wasn't in the van at the time, but the van wasn't searched other than to, enough to secure Charlie. But once again, he was given orders because an armed suspect. What was he doing? What was he arrested for? Was I assume that Kelly was not the armed suspect. So for all you know, Delete Lawz, Jane Doe might have been an armed suspect. For all you know. But you just say, well, he was allowed to be arrested because he wasn't participating in the exercise of his constitutional rights. What was he arrested for? Obstruction? Probably. Just like you. Obstruction isn't a constitutional right. Defendants only allege that Bork had probable cause, not the rest of the defendants. If Bork had probable cause to arrest you, that means there is probable cause to arrest you. So all the other officers who assist on the arrest of you, they're using that same probable cause. Now, I think this is what he's trying to argue. And it would be utterly ridiculous to require this. So he's trying to argue that if the arresting officer has probable cause, but has not laid out exactly what that probable cause is to assisting officers who arrive on the scene after he has decided to effectuate an arrest, that any assisting officer is violating your rights because they don't know what the probable cause is. That's ridiculous. That's absolute nonsense. In a lot of situations, you don't have time. It would be dangerous to lay out, well, this is the probable cause, but these might be the mitigating factors, and do you think we really ought to arrest him? Do you think we have probable cause? And by then the officer has been run over by the defendant because they had to lay out a dissertation on probable cause to the assisting officers before they could assist in making the arrest. That's ridiculous. If there's probable cause for an arrest, there's probable cause for an arrest. the assisting officers don't have to develop their own probable cause. That's ridiculous. That's asinine. It cannot work that way. So they only allege Bork had probable cause because probable cause was developed while only Bork was there. None of the others needed to develop independent probable cause. You were not arrested. You were arrested because of what you did with Bork. That's it. More misconstruing of the facts by defendants. Motion 8(3) through 12. Let's see. Let's read motion 8(3) through 12. Here, Officer Bork was the only officer on scene and the person most familiar with the dangers of individuals inserting themselves into traffic stops. The following facts are undisputed. 1. Officer Bork noticed DeCastro approaching the traffic stop and interacting with the with the subject of the traffic stop. 2. Officer Bork told DeCastro to distance himself from the traffic stop. 3. DeCastro only backed away 5 feet and remained in a position close enough to interfere. 4. Officer Bork warned DeCastro that Officer Bork would detain DeCastro if he would not back up further. 5. DeCastro claimed he could stand next to the traffic stop and film and refused to comply with Officer Bork's order to move a safe distance away. That's not misconstruing the facts because that's what we saw in the video. So defendants say that it's undisputed that Bork noticed plaintiff approaching the traffic stop and cites the First Amendment complaint. That's not alleged in the First Amendment complaint. Plaintiff does not say what he witnessed happening inside of Bork's vehicle. Defendants say that plaintiff alleged staying close enough to Bork to interfere, but this is false and it is not alleged in the First Amendment complaint. The video recording of the event does not lie, nor does the video have bias. Defendants say that plaintiff further admits in the First Amendment complaint that he refused to move a safe distance away. This is false, and it is not alleged in the First Amendment complaint. Except they told you to, that they're admitting you moved up to 5 feet. I dispute that it's 5 feet. It was more like 2 or 3 feet, but they said that's not enough. Keep moving back, and you refused. So if they told you keep moving back, that would imply you were not at what they deemed to be a safe distance. So this is false and not alleged in the First Amendment complaint. Defendants allege that plaintiff admitted that he intended to interfere with the traffic stop based on his flawed understanding of the First Amendment, but this is false and it is not alleged in the First Amendment complaint. Further, NRS 171.1233 makes it unlawful for Bork to interfere with plaintiff's recording of the police. Finally, Bork has had training on the rights of citizens to record interactions with the police, and he did not follow what he was taught. Oh, so you've obtained Officer Bork's training records in discovery. Wait, discovery hasn't happened yet? And it makes it unlawful for Bork to interfere with recording of the police. And that's taking him up at his word of what NRS 171.1233 even says. But did anyone hear? Did anyone hear that Officer Bork says, "Hey, you can't record this. Hey, stop recording. Hey, put down that phone"? No, he said, "Move back." keep moving back. Let's see. Let's see if I can find. Well, we'll have to. 171. Well, let's. Come on. S. So he says NRS 171.1233 makes it unlawful for Bork to interfere with plaintiff's recording of the police. But NRS 171.1233 isn't in the First Amendment complaint. It's not alleged. It's irrelevant. So you bringing it up here further is irrelevant. I mean, he for all he complains, well, that, you know, I didn't allege that Jane Doe was in a traffic stop in the First Amendment complaint. I alleged she was in a police encounter. You didn't allege NRS 171.1233 in the First Amendment complaint. Would you like to have your cake and eat it too? We're going to end up with fatter delete laws. All that cake. Plaintiff's counsel attempts to enter testimony without a declaration. Delete Lawz hasn't entered any declarations. Bork is not protected by qualified immunity under federal civil rights claims, nor are the other officers. Defendants only allege that Bork is protected for his violation of plaintiff's Fourth Amendment claims for false arrest. Bork does not allege protection for qualified immunity for his violation of plaintiff's other Fourth Amendment claims or his claims under the First or 14th Amendments. None of the other defendants plead qualified immunity. Defendants cite Matos versus Agarano, 9th Circuit 2011, which they say requires the analysis of analogous case law to see if the officer should have known that they were breaking the law. However, officers can still be on notice that their conduct violates established law, even in novel factual circumstances, citing Hope versus Peltzer from the Supreme Court in 2022. See also Giebel versus Sylvester, Ninth Circuit 2001. Did he get these from GTP? Has anyone checked that these are legitimate citations? So even if there is no closely analogous case law, a right can be clearly established on the basis of common sense. But you don't have the right to obstruct. I mean, how many people have been convicted of obstructing with a phone in their hand, with a camera in their hand, and it's been upheld because you don't have the right to obstruct. In novel factual circumstances, officers are not entitled to qualified immunity in obvious or egregious cases. Taylor v. Riojas, Supreme Court 2020. Put simply, qualified immunity protects all but the plainly incompetent or those who knowingly violate the law. Mullinex versus Luna, Supreme Court 2015. Defendants then cite 2 Washington state cases that obviously weren't enforcing a Nevada statute. Defendants then cite many cases to try to prove probable cause, but still fail to state what obstructing law that plaintiff violated. Except they cited it. Shall we look at it again? Hang on. Wrong one. Where was it? Where was it? Yeah, I don't want to search for it again. But we saw it. We saw NRS something or other. Just because it's not good enough for Delete Lawz doesn't mean it's not there. It's in the motion to dismiss. But I don't get how he can say, unless, like I've said, it's some combination of either he is fundamentally dishonest or he is an utter abject moron. But to say, well, they still fail to state what obstructing law plaintiff violated, but it's in there. It's even in the section he cited. He pointed me directly to it last, like not in this section, but above the first time he said it's not there, he pointed me right to it. Probable cause is a question of fact. United States versus Magoyan Lopez, Ninth Circuit 2016. See also Baranda versus Richmond, Ninth Circuit 1988. Where the facts or circumstances surrounding an individual's arrest are disputed, the existence of probable cause becomes a question of fact for the jury. Here, plaintiff and defendants dispute the facts. But you saying there is no probable cause doesn't make it a fact. That's a statement of the law. That's a legal conclusion. That's not a factual conclusion. The judge, even at this stage, the judge looks at the facts, just like it says here. It becomes a question of fact for the jury. The judge looks at the facts you have alleged and says, based on those facts, is there probable cause? You saying there is no probable cause is a conclusory statement that is not taken as fact. See Ashcroft versus Iqbal and Bell Atlantic versus Twombly. Additionally, Borks initially threatened to arrest plaintiff for obstruction if he didn't mind Jane's privacy. Then in his report, Bork complained about not having enough space. Of what, he doesn't say. And now apparently Bork is making the typical yet vague arguments of officer safety. He didn't say you'd be obstructed if you didn't mind her privacy. He said, move back. The facts are certainly in question. But that's the standard for summary judgment, not 12b-6. And Burke's changing testimony should certainly go against his credibility. He hasn't provided testimony, period. There's no testimony. No one has testified. Bork hasn't submitted an affidavit that's before the court. There is no testimony. How can there be changing testimony when there is no testimony? There are pleadings. Officer Bork has done no pleading. Once it is established that Bork didn't have probable cause, which is certainly alleged in the first amended complaint noted above, the relevant case law for defeating qualified immunity will be about violating plaintiff's rights, regardless of what crime the police officer was allegedly enforcing at the time. I'm going to lose my mind. I'm going to lose my mind. I thought Ashley Giard broke me. Delete Lawz is breaking me too. He's going to do it. I mean, once it is established that Bork didn't have probable cause, which is certainly alleged in the first amended complaint and noted above, that's a conclusory statement. It's conclusory. At some point, Captain Conclusory needs to learn what a conclusory statement is. And he needs to learn that conclusory statements are not taken as fact. Especially not conclusory statements of the law. The judge gets to decide. The judge looks at the actual alleged facts in the complaint. I know I'm a broken record, but he keeps getting it wrong. So I'm going to keep repeating it because I, as you know, I don't watch his videos. He's awful. But I did see another creator was covering one of his recent Vegas videos. And he says there are a few lawyers who cover him and they are biased dunce caps. Now, I'm certainly biased against him. I'm on the record. I absolutely I despise him. But I'm also on the record that I absolutely despise Josh Abrams. I despise them equally. I absolutely want Josh Abrams to defeat the claims that Delete Lawz has made against him. Not because I prefer Josh Abrams. Like I said, I don't. I wish both of them would disappear off the internet. I want Josh Abrams to prevail because it's the legally correct decision. I want the appropriate party to win. If I thought Delete Lawz rights were violated, I would say so. I would absolutely say so. I absolutely dislike the police violating people's rights. It happens, and police need to be held to a higher standard. Delete Lawz, what he does is not the way to hold them to a higher standard. And am I a dunce cap? Well, I think the more appropriate question would be, am I a dunce? I make absolutely no claims that I'm the smartest person in the world. I'm the second smartest at best. I don't know everything. But I'm reasonably intelligent, and I graduated law school with honors. I'm a licensed attorney. Well, I do need to pay the extortionate bar dues, so yeah. That's all to say, though, that while I might be biased against him, I'm going to do my absolute best to state what the actual law is, what the actual standard is. And he's presumably aware of me. I mean, I know he's aware of Merb, who covers him. I know he's aware of Artie from Artie's Corporate Fiction, who covers him occasionally. But of the attorneys who cover his legal filings the most, it's between Merb and me. So when he says there are a couple of attorneys who cover him and they're biased and dunce caps, I can only assume that means me. And that would mean he's aware of me. And in order for him to know I'm biased and a dunce cap, it would mean he watches my videos. So the reason I keep like a broken record repeating myself, saying conclusory statements are not taken as fact, Statements of the law, misstatements of the law are not taken as fact. The reason I keep repeating that is on the hope that he listens to me and stops. But let's keep going. Currently, there are plenty of cases that have ruled on one of Nevada's obstruction laws when used to chill someone's constitutional rights. Which obstruction laws would those be? Martinelli versus Beaumont, 9th Circuit. Carey versus Nevada Gaming Board, 9th Circuit. Patterson versus Von Buena, District of Nevada. Additionally, qualified immunity does not extend to a public official who enforces a statute that is patently violative of fundamental constitutional principles. Dittman versus California, 9th Circuit. Cert denied in 2000. Obstruction. He thinks that obstruction statutes are patently violative of the fundamental constitutional principles. He's delusional. I mean, can you imagine if Delete Lawz, the second most delusional person on the planet, procreated with Ashley Guillard, the most delusional person on the planet? Their offspring would be so delusional. I mean, so my first year of undergrad, I took Calculus 1. And my professor was an Englishman, and he was interesting. Instead of shooting projectiles into space, we'd shoot Gary the Gerbil into space. But he would also say, when you divide by 0, the universe explodes. Delete Lawz, procreating with Ashley Guillard, would be the genetic equivalent of dividing by 0, and I'm convinced the universe would explode. Moreover, obstruction and resisting are the two crimes most often included in a contempt of cop charge, where a citizen hurts a police officer's feelings while that citizen is exercising his freedoms. Citing Mitchell versus City of Henderson, District of Nevada, 2017. Contempt of cop. You're not going to get very far with that kind of language here. The court is not going to look at you favorably. State law false arrest claims do not qualify for immunity. Motion 1014 through 11.4. Let's look. So state law claims, defendants are immune from liability from the state law claims on the basis of discretionary function immunity pursuant to NRS 41.032. And so let's keep that in mind. For state law claims, They are citing a state law on which state employees have state qualified immunity. This being in federal court doesn't matter. The state decides who has qualified immunity under state law, even under federal law. Like, in order to sue the state of Nevada, you've got to ask the state of Nevada for permission. The state of law allows you to sue the state of Nevada. Defendants try to cite Gonzalez versus LVMPD from, is this federal, or I assume it's District of Nevada, 2013, for discretionary immunity when they're aware that Gonzalez is inapposite due to its warrant issues, which made it distinguishable and fall under the second element of Martinez versus Marshak from Nevada Supreme Court, I assume, in 2007. Defendant's citation of Santiago at 1027 has the same issue. Additionally, and tell us, like, you just say, well, in this case, you don't tell us why it's different. He makes a very bad lawyer. Additionally, Mack v. Williams has established that there is no qualified immunity under Nevada law. Discretionary immunity would be qualified immunity. I mean, there is no qualified immunity under Nevada state law, and yet they cite to the discretionary function immunity pursuant to NRS 41.032. That would be a Nevada state law. That is immunity, discretionary immunity. That would be qualified immunity. I mean, there's no qualified immunity under Nevada law, even though they cite a Nevada law providing for immunity. Plaintiff properly alleges an equal protection claim. Defendants try to cite pleading requirements of Lee versus City of Los Angeles, Ninth Circuit 2001, where they know that the Ninth Circuit has held that this heightened pleading standard no longer applies. See Galbraith versus County of Santa Clara, Ninth Circuit 2002, and where they know, you don't know what the hell they know. The standard for proving discriminatory effect is a demanding one. Yet, to state a claim, a plaintiff need only allege some facts, either anecdotal or statistical, demonstrating that similarly situated defendants could have been prosecuted but were not. Citing Lacey versus Maricopa County, Ninth Circuit, 2012. Plaintiff alleges those facts at First Amended Complaint, Section 53. So, So choosing to detain plaintiff, a member of the press, based on the alleged actions and or involvement of other members of the press and due to the color of his skin is illegal profiling and prohibited by the 14th Amendment's Equal Protection Clause and NRS 289. If the defendant had been told that a man of their skin color trying to get police officers' autographs, and that's nonsense. So he in paragraph 53 has not alleged that other people have obstructed without being arrested. But he's lying again. He's lying again. That's the only conclusion I can come to. Because to state a claim to prove discriminatory effect is a demanding one. To state a claim, you need to allege some facts, either anecdotal or statistical, demonstrating that similarly situated defendants could have been prosecuted but were not. Statistical. You haven't said 53% of First Amendment auditors who are told that they can keep filming but have to move back were not arrested. You haven't even, not even anecdotal. But even then, it's got to be discriminatory effect. You've got to say 70% of white First Amendment auditors are not prosecuted, but 93% of black First Amendment auditors are. But like, they didn't even know, like, you present as whiter than me. Their mention of your lips, that they thought it was about them thinking you were on drugs, not being white. Besides which, it was, why are your lips so white? That was the statement. That, like, there's absolutely no discriminatory intent that can even be thought of from that. It's ridiculous. But like, if you were to allege, well, my name is Jose de Castro, that's Hispanic, so they discriminated against me because I'm Hispanic. They arrested you before they knew your name. To fit a class of one claim under Village of Willowbrook versus Olek, Supreme Court 2000, plaintiff is a member of an identifiable class. Plaintiff was treated differently from others similarly situated. There is no rational relationship to a legitimate state objective. Seriously? Seriously. What is the identifiable class? What's the identifiable class? These are all conclusory statements. You saying you're a member of an identifiable class is conclusory. What class is it? Is it Hispanics? Is it the press? The press isn't a protected class. There's freedom of the press, but it's not a protected class. You're treated differently than others similarly situated, than other Hispanics, than other races, than other members of the press. What is it? How are you treated differently? this is a conclusory statement. Who did what you did and wasn't arrested? And there is no rational relationship to a legitimate state objective. Now that is just laughable. So, in analyzing constitutional law, you've got to know what the scrutiny level is. Is this strict scrutiny? Strict scrutiny, it's got to be the least restrictive. I'm going to get this a little bit wrong because it's been a while since I took constitutional law and I haven't cited it off the top of my head recently. But it's got to be the least restrictive means to achieve a legitimate government need, basically, a legitimate government objective. The least restrictive method. And then there's medium scrutiny, which I can't remember off the top of my head the exact, but. And then there's rational basis scrutiny, which is basically any rational explanation for stating a government interest is good enough. So he says there is no rational relationship. So that's rational basis of the legitimate state objective. The rational basis, the rational relationship to a legitimate state objective would be officer safety. That's enough. That's enough. Officer safety. Or how about the state has the interest, the legitimate state interest in safe roads. Therefore, the cops need to be able to carry out their functions and carry out their investigations into traffic violations without interference. That's a rational state interest. I bet you guys can come up with 100 more. It's rational basis. Any rational explanation is good enough. Plaintiff must point out defendant's contradictory statement. De Castro never asserts he was discriminated upon his unknown race, only that he believes he was arrested for the color of his skin. Defendants go on to say that conclusory statements about similarly situated individuals is not valid after they cited Lacey, which says otherwise, as noted 2 paragraphs up. Huh? This doesn't say conclusory is enough. It says you need some facts, either anecdotal or statistical. It doesn't say conclusory statements are enough. You still need some facts. Does he seriously think that Lacey says that conclusory statements get you far? Of course, Captain Conclusory would invite the court to hold that conclusory facts are enough. They're not. Even based on Lacey, they're not. I mean, the anecdotal would be saying, this person that I know wasn't arrested, this person that I saw wasn't arrested, that, I witnessed someone not being arrested. That would be the anecdotal or statistical. But those are still factual. Those are still factual allegations. They're not conclusory. He is so stupid. Maybe the second to bottom of your high school class does not make you a lawyer. There's a reason. Like, I'm not a fan of the bar. I'm especially not a fan of the bar exam. But there's a reason why there are standards for lawyers, and Delete Lawz does not meet those standards, not by a long shot. Plaintiff properly alleges a First Amendment retaliation claim. Plaintiff was arrested when other similarly situated individuals engaged in the same sort of protected speech had not been. What? Okay. When others had not been arrested. When other similarly situated individuals engaged in the same sort of protected speech had not been. But once again, it's not about your speech. It's about you not backing up. It's about you interfering. In general, defendants fail to recognize that the right to record police stems from the First Amendment, and plaintiff's claims for First Amendment retaliation aren't simply based on his protests. Seriously, defendants fail to recognize, plaintiff fails to recognize that he was not arrested for recording. He was arrested for interfering and for obstructing. Two different things. Defendants try to enter contradictory facts again. This is false, and it is not alleged in the First Amendment complaint. Defendants offer no evidence to support their contradictory statements. Well, I guess we'll have to look at their motion to see what that allegedly contradictory statement was. 1022. Wait. Make sure. 1222. So, as discussed above, probable cause existed for the arrest. Or is he? I mean that's all I can guess that alleged contradiction was, because otherwise he would have said 21 through 22 or 20 through 22. But since he said page 12, line 22, that's the only thought that is entirely on line 22. As discussed above, probable cause existed for the arrest. But this is false and is not alleged in the First Amendment complaint. But they're saying, based on the facts in the First Amendment complaint, the allegations in the First Amendment complaint, there was. Their argument is not a fact. Arguments are not facts. Legal conclusions are not facts. Delete Lawz' wrong legal conclusion that there was no probable cause is not a fact. So the fact that there being probable cause was not alleged in the First Amendment complaint is irrelevant, because that's a legal conclusion, not a fact. So it's who cares? This is nonsense. Plaintiff properly alleges a Monell and supervisor liability claim. The specific injury relates to the specific unconstitutional policy. The policy was deliberate indifference. Defendants try to cite City of Oklahoma City versus Tuttle from the Supreme Court in 1985 as requiring more than proof of a single incident, but Leatherman versus Tarrant County Narcotics Intelligence and Coordination Unit from the Supreme Court in 1993 says otherwise at 198. Plaintiff has identified a policy. Plaintiff has explained how the policy is deficient. Plaintiff has explained how the policy caused him harm. Plaintiff reflects on the policy's deliberate indifference. Plaintiff's statements aren't conclusory, except they are. They're conclusory. I mean, he's presented no evidence whatsoever of any kind. He has not stated any formal policy, and so any informal policy is explicitly from this one encounter. So it at best it's his experience, but that's an experience of one. That doesn't make a policy. That doesn't make an informal policy. That's asinine. So him saying, well, this is their policy because I said it's their policy. That's conclusory. That's the very definition of conclusory. It can't be anything but conclusory. Oh. I thought we'd get at least through this faster than the Schofield. I don't know. I don't understand it. This is such nonsense. And this is only 13 pages as opposed to 31 pages of nonsense from Schofield. Well, from Giard. How does 13 pages of bullshit from Delete Lawz take the same amount of time as 31 pages of the same from Ashley Giard? I don't get it. I don't get it. I hope you guys appreciate this, because it's that they're gonna have to take me away to the funny farm, or my favorite name for it, the booby hatch. It's gonna drive me to drinking, and I don't drink. I think it's nasty. Even the smell is oof, but it's gonna drive me to something. Defendants try to rely on Spiller versus City of Texas City Police Department from the Fifth Circuit in 1997 to say that description of a policy can't be conclusory, but they know that Svirkovitz versus Surima N.A. from the Supreme Court in 2002 says otherwise. I highly doubt it. I highly doubt it. Let's call him on his bullshit for once. So the holdings, plaintiff, a plaintiff in an employment discrimination case need not establish her prima facie case in the complaint. Rule 8A's simplified pleading standard applies to most civil actions, and that prima facie case is an evidentiary standard, not a pleading requirement. You'll notice this is a case from 2002. You'll notice it's cited by Bell Atlantic versus Twombly in 2007, which itself was cited by Ashcroft versus Iqbal in 2009, I think. So, like, court listener doesn't shepherdize this. Let's take a look on LexisNexis. So, Federal Rule of Civil Procedure 8A2 provides that a complaint must include only a short and plain statement of the claim showing that the pleader is entitled to relief. Such a statement must simply give the defendant fair notice of what the plaintiff's claim is and the grounds upon which it rests. This simplified notice pleading standard relies on liberal discovery rules and summary judgment motions to define disputed facts and issues and to dispose of an unmeritorious claims. Facts. A 53-year-old native of Hungary filed a suit against his former employer, alleging that he had been fired on account of his national origin and his age in violation of Title VII of the Civil Rights Act of 1964 and the Age Discrimination in Employment Act of 1967, respectively. The trial court dismissed the complaint. On appeal, the trial court's decision was affirmed on the ground that employment discrimination complaint required the employee to allege facts constituting prima facie discrimination, and the employee's allegations were insufficient as a matter of law to raise an inference of discrimination. The case was elevated to the Supreme Court of the United States on cert. Issue: was the complaint sufficient to state a claim? Yes. The court held that an employment discrimination complaint need not contain specific facts establishing a prima facie case under the McDonnell-Douglas framework, but instead must contain only a short and plain statement of the claim showing that the pleader is entitled to relief. The court further held that the complaint satisfied the requirements of Federal Rule of Civil Procedure 8A because it gave the employer fair notice of the basis for the claims. The employee alleged that he was terminated on account of national origin and age. His complaint also detailed the events leading to his termination, provided relevant dates, and included the ages and nationalities of at least some of the relevant persons involved with his termination. The court concluded that the allegations stated claims upon which relief could be granted. So that's basically the law school brief, but yeah, I thought that we'd be paywalled out of there. And all I want is, let's see if case briefs gives it to us. This is annoying. This is annoying. What, you may ask, is annoying? So, on Westlaw or LexisNexis, the which we were paywalled out of going to the full case text instead of just the law school brief. When you click on any case, it's going to have a little flag icon right at the top or something similar. And that flag icon is either going to be green or blank, meaning this is good case law. Yellow, meaning, hey, something in this has been overturned, but there still might be good case law in this, or it'll be red saying this has been overturned. This being a 2002 case on the pleading standards under Rule 8, this, like I said, is before Twombly and Iqbal. In fact, it's cited by Twombly. I mean, Delete Lawz may as well have cited the Conley versus Gibson, which was sort of the standard for Rule 8 pleading standards before Twombly and Iqbal. Because he says, based on a 2002 case, that for Rule 8 standards, it can be conclusory. That's fine. Except Twombly and Iqbal say no. Conclusory is not good enough. But I'm guessing on Westlaw, this at least has a yellow flag, this case, if not a red flag. Because Twombly and Iqbal, they don't agree. They're newer. They are the controlling law for Rule 8. But, you know, if Delete Lawz knew anything about the law, he'd maybe be able to figure that out. Not every case citation is a good case citation. If I did this, you better believe I'd be sanctioned for this, assuming this is bad case law, which I'm assuming it is. The judge would tear me a new one. Oh, it would not be pretty. It would not be pretty. Not one bit. But I'm sure that Craig Anderson Esquire will let us know in the reply. So, defendants largely overlook plaintiff's supervisor liability claims against Tory. Plaintiff properly alleges a 42 U.S.C. Section 1981 claim. Defendants largely misunderstand a Section 1981 claim in their argument. Plaintiff is clearly alleging that police services provided to plaintiff were not provided in an equal way, nor was plaintiff able to enjoy the services at the barbecue in an equal way, including the use of the parking lot. He argues earlier that the owners of the barbecue had a property right in their parking lot and that the police violated that property right by conducting a traffic stop there. But he had the right to film in that parking lot, period. Even though under his earlier argument, you'd think, hey, the purpose of that parking lot is only to park in it to go into the barbecue. Well, if he wasn't parking there to go into the barbecue, how was he not provided an equal opportunity to enjoy the services of the barbecue? He's never alleged. There's no allegation that he was there to enjoy barbecue. He was there to film the police. Plaintiff properly alleges an invasion of privacy claim. Defendants argue that if there was a probable cause to arrest plaintiff, then the search incident to arrest is legal. However, the first amended complaint says that there was no probable cause. That's an improper legal conclusion. I feel like a broken record. I really do. I feel like a broken record, but he keeps saying this as if the court has to give this any weight whatsoever. You saying there was no probable cause doesn't mean there wasn't probable cause, even though it's in the complaint. That's not a factual allegation. That's a conclusion, a legal conclusion. That makes it. Say it with me. Say it with me. Conclusory. How does he not understand after all this time what conclusory means? I mean, he even argues, well, this can't be conclusory. Either he doesn't know what conclusory is, yet he's arguing against his statements being conclusory, or he had to go look it up. What is conclusory? Then he'd know. Yet he still gets it wrong. Plaintiff properly alleges a state negligence claim. Defendants cite Ortega versus Reyna, Nevada, 1998, as providing immunity, but the law has since changed. Martinez versus Marushak, Nevada, 2007. Defendants overlook plaintiff's claims related to vicarious liability. Defendants overlook plaintiff's claims against the officers as individuals, whereas NRS 41.032 clearly doesn't apply. Clearly. If the court grants the motion to dismiss, it should allow leave to amend. Federal Rule of Civil Procedure 15 provides that leave to amend shall be freely given when justice so requires. The Ninth Circuit has held that this policy is to be applied with extreme liberality. Eminence Capital LLC versus Espion. Ninth Circuit 2003, which itself quotes Owens versus Kaiser Foundation Health Plan, Inc., Ninth Circuit 2001. Generally, a district court should grant leave to amend even if no request to amend the pleading was made, unless it determines that the pleading could not possibly be cured by allegation of other facts. Lopez versus Smith, Ninth Circuit 2000, en banc. Yeah. This garbage fire can't be cured by allegation of other facts. It can't. At least not until the criminal case has been concluded. But even then it won't, because there was probable cause to arrest. He was obstructing. He was interfering, which is obstruction. It's While plaintiff believes the court should deny a motion to dismiss in its entirety, to the extent the court grants the motion in any respect, plaintiff should be given leave to amend. Defendants, though, can't correct the deficiencies in their motion. Reply papers may only address issues raised in the moving papers. It is improper to introduce new facts or a different legal argument in the reply brief, citing Lujan versus National Wildlife Federation from the Supreme Court in 1990. Hey, we've seen that quotation before in Massachusetts. But here's the thing. You don't have to request a reply in Nevada. That's a local rule in Massachusetts. He's arguing they shouldn't even be allowed a reply motion. But they are allowed to address his arguments. He's so dumb. And then Gutierrez versus Cobos in the 10th Circuit says, a party waives issues and arguments raised for the first time in a reply brief. But funny enough, if the argument is raised for the first time in the response brief, that means it's not raised for the first time in the reply brief, so it hasn't been waived because it's new to the moving party. Conclusion. For the foregoing reasons, plaintiff respectfully requests that the court deny defendant's motion to dismiss in its entirety. Declaration of Jose de Castro. I declare under penalty of perjury that the foregoing is true and correct. Yeah, he thinks this gets him around having to submit declarations. I believe a certain judge disagrees. Or was that up in Idaho? I'm getting myself confused. Either way, let's we've been at this 3 hours and 22 minutes. And yet I think we can get through the 14 pages of the reply brief from LVMPD much faster than the 13 pages. Was 13 pages, wasn't it? Yeah, 13 pages of Delete Lawz Opposition. So let's race through this. Defendants, LVMPD, and the officers, by and through their attorneys of record, Marquise Auerbach, hereby file their reply in support of their motion for partial dismissal. This reply is made and based upon the memorandum of points and authorities, the pleadings and papers on file herein, and any oral argument allowed by counsel at the time of hearing. What day? When was this submitted? This was the 23rd. Frankly, I'm surprised that we didn't get a whining request for a sir reply, but hey. Memorandum of Points and Authorities. Introduction. This is a Section 1983 wrongful arrest and excessive force lawsuit. On March 15th, 2023, defendant LVMPD officer Brandon Bork arrested plaintiff Jose de Castro for obstructing the lawful traffic stop when he refused to comply with Officer Bork's commands to move a safe distance away from the detainee. De Castro asserts numerous causes of action under the theory that LVMPD defendants wrongfully arrested him for discriminatory reasons and for exercising his First Amendment right to film. The instant motion seeks dismissal of the majority of De Castro's claims for failure to state a claim upon which relief can be granted pursuant to 12b-6. Specifically, the motion requests the court dismiss De Castro's Fourth Amendment and Nevada state law false arrest and false imprisonment claims, first and eighth causes of action, 14th Amendment discrimination claim, second cause of action, First Amendment retaliatory arrest claim, third cause of action, Monell claim against LVMPD, fourth cause of action, 42 U.S.C. Section 1981 discrimination claim, fifth cause of action, State law invasion of privacy claim, 9th cause of action. State law negligence claim, 10th cause of action. The only claim that LVMPD defendants are not contesting are DeCastro's Fourth Amendment excessive force claim, 1st cause of action, and Nevada state law claims for assault and battery, 6th and 7th. Defendants acknowledge DeCastro has pled sufficient facts for the claims to continue. Notice they say for the claims to continue, not to prevail. They don't say they agree, they just say they acknowledge he has pled sufficient facts. Statement of facts. LVMPD defendants hereby incorporate the statement of facts as recited in the motion. DeCastro's facts section of his opposition brief does not cite to the allegations within the First Amendment. Instead is a narrative which includes several legal conclusions and other assertions not contained within the complaint. Additionally, DeCastro asserts in a conclusory fashion that he was detained without good cause, arrested without probable cause, searched pursuant to an illegal arrest, and repeatedly categorizes the conduct of LVMPD defendants as illegal. DeCastro's conclusory assertions of legal conclusions should hold no weight in this court's consideration of the motion. Legal argument. DeCastro's opposition repeatedly mischaracterizes the allegations within his own First Amendment complaint. It is apparent from DeCastro's First Amendment complaint the woman he refers to as Jane was detained pursuant to a traffic stop. DeCastro claims he never alleged the subject incident was a traffic stop in his First Amendment complaint. However, it is apparent from DeCastro's First Amendment complaint the incident DeCastro happened upon was a traffic stop, as the woman DeCastro refers to as Jane was sitting in a vehicle during an interaction with an LVMPD officer, as described by DeCastro. At a minimum, DeCastro never alleges, because he cannot, Jane was illegally detained. Thus, it is undisputed DeCastro's First Amendment complaint alleges he interfered with a lawful police activity involving a woman sitting in a vehicle. DeCastro argued First Amendment complaint never Jane was detained, and thus the LVM claim told the traffic detainee she was free to go. Similarly to the traffic stop argument, this court can reasonably infer from DeCastro's First Amendment complaint that Jane was a traffic detainee. DeCastro's First Amendment complaint asserts after the confrontation between DeCastro and Officer Bork began to escalate, Officer Bork told Jane to leave. Again, in the context of Jane sitting in her interacting with Officer Bork prior to being told to leave, and the statements of Officer Bork as cited by DeCastro, it is undisputed Jane was being detained for a law enforcement purpose. DeCastro offers no alternative plausible inference that could be drawn from the First Amendment complaint's allegations. DeCastro's characterization of the First Amendment complaint regarding Officer Bork's threat to detain DeCastro for obstructing is incorrect. Next, DeCastro argues the LVMPD defendants somehow misquoted the FAC by claiming Bork warned DeCastro he would detain DeCastro for obstructing if he did not move further away from the detainee. DeCastro argues, although Officer Bork used the term obstructing to characterize DeCastro's behavior, what really meant is the Officer Bork confronted DeCastro for the unrecognized crime of invading Jane's privacy. DeCastro also argues no evidence exists that DeCastro was warned against obstructing. DeCastro's arguments here miss the mark. The first amended complaint alleges DeCastro refused to move back more than 10 feet from the traffic stop, and Officer Bork threatened to detain DeCastro for failing to back away to a reasonable distance. Officer Bork specifically told DeCastro he was being detained for obstructing. Although the First Amended complaint also mentions Officer Bork said Jane deserves privacy, this is not your business. The allegations of the First Amended complaint make clear Officer Bork's stated reason for detaining DeCastro was obstruction. Similarly, LVMPD defendants are under no burden to attach evidence to support the claim DeCastro was warned against obstructing. Officer Bork's warning DeCastro not to obstruct is alleged by DeCastro in the First Amended complaint. DeCastro's attempt to change his First Amended complaint is irrelevant. All that matters is Officer Bork had probable cause for any crime. See Devon Peck versus Alford, Supreme Court 2004, which says when there is probable cause to arrest as suspect for any crime, the arrest does not violate the Fourth Amendment, even if that crime was not actually charged. See also Ewing versus City of Stockton, Ninth Circuit 2009, which held the same. Well, hey, that is almost like my analogy of criminal or felony speeding and DUI. The First Amended complaint acknowledges DeCastro did indeed refuse to comply with Officer Bork's detention. Next, DeCastro argues the LVMPD defendants improperly cited the First Amended complaint by stating Bork attempted to detain DeCastro and DeCastro refused to comply. Once again, DeCastro attempts to misconstrue the First Amended complaint in a manner that would require this court to draw unreasonable inferences. The First Amended complaint admits Officer Bork told DeCastro he was being detained. After that, Bork approached DeCastro, and DeCastro stepped away from Officer Bork and continued to protest the detention, which he categorizes as Bork putting his hands on DeCastro unnecessarily. Ignoring DeCastro's characterization of Officer Bork as angry and intent on manhandling, the First Amended complaint admits DeCastro was resisting and refusing to comply with the detention. DeCastro's raising issues of Officer Bork's intent and the legality of the detention have no bearing on the fact DeCastro resisted and refused to comply with the detention. Notice he's conjugating this properly. It wasn't a detainment, it was a detention. The Ninth Circuit has held the absence of probable cause does not grant an individual the right to offer resistance. See United States versus Spann, Ninth Circuit, 1992. See also Arpin versus Santa Clara Valley Transportation Agency, Ninth Circuit, 2001. The First Amended complaint supports Officer Bork's decisions. In Section 13 of DeCastro's opposition brief, he argues the LVMPD defendants misconstrued the First Amended complaint by stating Bork noticed DeCastro approaching the traffic stop, and DeCastro refused to move to a safe distance away from the traffic stop. Both statements are based from the factual content in the First Amended complaint. DeCastro alleges within 6 seconds of him approaching Jane's vehicle, Officer Bork confronted DeCastro. DeCastro does not explain an alternative inference, i.e., Officer Bork confront DeCastro of Jane's. Officer Bork did not notice DeCastro. any reasonable, often unknown, unsearched individual approaching a traffic stop and attempting to contact the detainee. Additionally, while the parties can disagree about what a safe distance means, it is undisputed DeCastro refused to move more than 15 feet away from the traffic stop and asserted his membership in the press gave him the legal right not to comply. The first amended complaint alleges DeCastro was arrested for protesting his arrest. Yeah, it doesn't make sense. You're arrested for protesting your arrest. It's like which came first, the chicken or the egg? The rooster came first, of course. In section 17 of DeCastro, he argued defense characterizes the by making up an allegation DeCastro was his arrest. However, at further complaints, paragraph 57, DeCastro retaliated protected his verbal protests and criticisms of the defendant's actions in investigating, detaining, and arresting DeCastro, as well as his exercise of the right to record police interactions. DeCastro makes several false claims about LVMPD defendants' motion. LVMPD defendants accepting DeCastro's allegations as true on a 12B5 motion to dismiss as a Castro my interest. 5 and opposition claimed LVMPD defended a number of DeCastro's allegations by allegations with as true of the instant motion. As this court, LVMPD are to accept context of a 26 motion to okay, I'm back, hopefully. Okay. Uh, uh, defendants accepting Castro's allegations the limited dismiss the claims for failure to state a claim upon which relief can be granted cannot be construed as an admission to any allegation within the first amended complaint. Accordingly, contrary to DeCastro's arguments, LVMPD defendants have not admitted to anything in the motion. LVMPD defendants did not misstate DeCastro's claims in the motion. In section 7 of DeCastro's opposition brief, he argues defendants largely assume state law claims where there are also federal law claims and skip over all state constitution claims in plaintiffs' first amended complaints. I had a lot of trouble figuring out what that was supposed to mean. To the contrary, the LVMPD described the causes of those first amendment Page 5, compared to ECF number 13, state in the first scene. My internet's protesting about this going on too long. We'll try and make it through. LVMPD defendants' clerical error in referencing the original complaint does not negate LVMPD defendants' substantive arguments. In Section 10 of De Castro's opposition brief, he argues the motion cites the original complaint at ECF number 1 instead of the active first amended complaint at ECF number 13, and makes arguments about that now irrelevant document. In actuality, the LVM citation was a clarification on the LVM motion. Moreover, single citation to ECF's amended complaint within the complaint. As such, reference to ECF number 1 is a clerical. The motions not test attorney. Hey, remember, officer born to. It's all arguments. Section 14 counts to enter declaration. Assuming that De Castro meant LVMPD Defendants Counsel, LVMPD Defense Counsel's propounding of legal argument is not the same as LVMPD Defendants Counsel entering testimony. And let's look at footnote 1. De Castro's opposition brief contains 2 Section 14s. Here, the LVMPD defendants are responding to Section 14 of ECF number 27, page 7, paragraphs 17 and 18. Or lines 17 and 18, whatever. Okay. De Castro fails to state a 42 U.S.C. Section 1983 Fourth Amendment or state law false arrest claim upon which relief can be granted. First and eighth causes of action. Fourth Amendment false arrest. In Section 11 of De Castro's opposition, false arrest claim survives because he arrested without the entire premise PD the allegation demonstrate Officer Bork conclusion of law. Officer Bork lacked probable cause to arrest way of the which De Castro refused to comply with Bork's commands to net is not StreamYard. So in this net of this, so anyway, everything like for shorts and